Mr. Michael Roscoe. Very good. I see Mr. Roscoe. Good morning, sir. And I see Ms. Mogensen. Wonderful. All right, Ms. Mogensen, you're the appellant in this matter. If you're ready to proceed, please go ahead.
I am. Thank you. I would like to reserve the full 5 minutes for rebuttal, please.
Very good, ma'am. And whenever you're ready, the court is ready.
Good morning. Andrea Mogensen on behalf of appellant Christopher Lewis Brady. As the court knows, this is a criminal case. I think I would like to begin with our argument that the judgment of acquittal should have been granted for two reasons. First, and probably foremost from our point of view, because it would result in discharge, because it was not proven that Christopher Brady knew the document was forged at the time that the document was uttered. I did put in my brief, Lynn versus State seems to be the seminal case on what the elements of uttering a forged instrument are, and that in order to be guilty, you have to utter as true a document known to be false with the intent to harm or defraud. The intent to harm or defraud and the knowing of falsity must be at the time of the uttering. And as the court knows, factually, there were two twin brothers that appeared, and there was a dispute over which twin brother actually uttered the instrument. But the jury decided that it was Christopher Brady, and assuming that that's true, it was not shown that Christopher Brady knew that the instrument was false at the time of the uttering. The case that the instrument was a forged court order from a family law case involving Matthew Brady, not Christopher Brady.
And if I may, Ms. Mogensen, would you agree with me that the jury was able to hear all the evidence presented, and it was really left up to the jury to make a credibility determination as to, number one, because they are twins, and there was testimony presented as to who is the one that actually handed over the forged document, in this case. Wasn't there testimony that someone overheard that the twin brother Matthew made a comment from the truck, "I want to see my child," or something to that effect?
There was, and I do think that that's an appropriate question for the jury, and I don't think the issue of which twin actually uttered is at issue on appeal for that very reason. But what remains at issue is whether Christopher Brady, if we presume that he was the person that handed the instrument to DJ Howard, the man at the door, knew at the time that he gave that instrument to him that there had not been the entry of a court order allowing his brother to see the child.
But I guess what I'm relating, and the minute I use that as an example, doesn't that all these facts presented to the jury, because we're dealing with the statements, whether or not he knew, whether it's a question of fact. It's a question of what it is, what knowledge that he had. And so the jury gets to hear all that evidence presented, and including the testimony that I just mentioned about the brother. They take that all into account and make a determination. Well, the brother at trial is making the comment, "Oh, it was me, it wasn't my brother, it was me." It's a credibility call. And so doesn't that all tie in together in making that determination?
Well, as the court knows, the question for this court, pursuant to Bush versus State, is whether there's competent, substantial evidence of each element of the offense. And I think there was a great deal of focus at trial on who passed the document. But even if Matthew Brady was in the truck and said, "I just want to see my child," that does not give Christopher Brady at the door the knowledge that the court order in his hand wasn't issued by a court, that it was manufactured by his brother. That was not shown. The state is incumbent.
And how do you, and if I may on that one issue, there was evidence presented that Christopher Brady was a lawyer, correct? He is an attorney. He was an attorney at the time. That was correct?
Yes.
Okay. And was there testimony that was presented was as an attorney, if he had this document in front of him, there was evidence that, okay, several things in the document just seemed, there was no seal, the honorable was misspelled, anything of that nature. Do you think that also ties in to that issue?
I think that goes to a should have known standard, which has been held to be insufficient in Lynn versus State and Ginn versus State, both second district cases from 2006 and 2010. That a person should have known the document was forged from the circumstances is insufficient to sustain a conviction. So, I understand what the court is saying. There was evidence that he should have known, and the state proceeded on a theory of should have known, but that's been long held to be the incorrect standard. They have to show that he did know, and not that he found out afterwards and tried to fix it afterwards, but that he knew at the time of the uttering. The other issue for judgment of acquittal is venue, and I think that's a very clear area for reversal. As we talked about, the elements are that the uttering and the knowing that the document was false at the time of the uttering and the intent to harm or defraud at the time of the uttering. And there's no question that the uttering was in Charlotte County and not Sarasota County, Florida.
Help me out, Ms. Mogensen. What was the judge? Because the judge was provided with that motion. And what was the judge's reasoning for denying the venue issue?
The judge searched for a nexus to Sarasota County, and he felt that if he could find sufficient nexus to Sarasota County that he could deny the motion. But Berry versus State, 306 Southern 3rd, 1256 from this court provides a good example of why that is not the proper standard. That's more of a civil standard of venue. But in Berry versus State, that was also an attempt to defraud. And it was an auto accident in DeSoto County where the insured who resided in DeSoto County called the insurance company and claimed fraudulently to have been in the vehicle when the vehicle was hit when it was empty. And the facts that were developed in that case was that the accident was in DeSoto County, that the insured asked that he be contacted at his residence or PO box in DeSoto County, and that he claimed to have visited a hospital in DeSoto County. But this court held that that was insufficient because the question of venue pursuant to Florida Statute 910.03 sub 1 is where the offense was committed. And because it was clear from the phone call that was played at trial that the accused was driving, and the state did not show that that person was driving in DeSoto County at the time that they made the fraudulent report, this court reversed for a lack of proper venue. It could have been developed.
But Ms. Mogensen, isn't this situation a little bit different than that? I mean, the order that was forged was that of a Sarasota judge. And that in Berry, you have, a two-way communications device. But here, without the forgery of the Sarasota order, there would have been no reason for the defendant for any of these things to have happened. That really is the key event that happened here, was the forging of Judge Bonner's signature on a false order. Isn't that right?
Well, the plain language of 910.03 sub 1 is that you should be tried where the offense is committed. And there's no question the offense was committed in Charlotte County. So I don't think that it's the trial court's option to reach behind the plain language of the statute regarding venue and search for a nexus, because you could say in the Berry case that but for the accident in DeSoto County, there would have been no fraud, and therefore the venue was proper in DeSoto County. But in Berry, that's not the case because of the plain language of the venue statute.
So let's assume for a minute that you're correct about that, and your position is that your client gets discharged. Your opponent's position is that it wouldn't be double jeopardy for your client to be retried in Charlotte County. Please speak to that.
What I think the circumstances there is that should Charlotte County bring charges, that Mr. Brady would then move to dismiss for double jeopardy, and that issue would be argued by both sides in the trial court. And if the aggrieved party takes it up on appeal, that question would be answered then. I don't think we have sufficient preservation of that issue at the trial court level in this circumstance. And certainly we didn't make any argument about retrial, the state or the defense, when the motion for judgment of acquittal was denied. So I think that that's a distinct possibility. Legally, that may be the case, but I think that's a question for another day, presuming that Charlotte County picks up the charges and there's a motion to dismiss fraud. I don't think that that's been preserved or argued for this court's consideration.
But at least you don't disagree that your client could be retried. This isn't an automatic discharge.
I don't. I think that the proper thing to do pursuant to Berry is to vacate the conviction and remand. And then if Charlotte County decides to bring charges that I'm sure Mr. Brady would bring a challenge, he may win, he may lose. The aggrieved party would then have an opportunity to have fully researched that, flesh that out, and present it to this court if they choose to do that. The other issues that we raised were the non-unanimous verdict, which I think is a very critical issue that seems to appear with regularity. The state relied on the Miller case for that, but the Miller case actually found that the non-unanimous verdict that was invited by the state's argument was error, they found it to be harmless error. And the reason for that was because the state proved both versions of the crime. There was sufficient proof for a prima facie case for both versions of the crime that were argued by the state. Here, it would appear that the multiple listings of potential people that could have been defrauded, all but DJ Howard would be non-criminal because the instrument was uttered to DJ Howard Jr. as compared to DJ Howard Sr. And that to say that if Bethany or the attorney, Nick Osanti, or the clerk of court was defrauded, that the jury could find and convict on those potential victims would be non-criminal. So it's a very, very troubling non-unanimous verdict situation because the alternatives to DJ Howard Jr., in my view, are non-criminal. You can't say that that Christopher Brady intended to defraud anyone except for the person that he handed the document to in an effort to see the child at the moment.
This argument was not preserved, so you want us to view this as fundamental error.
I do, and I think it is fundamental error pursuant to the case law presented in our brief. Because it's non-criminal alternatives, to be convicted of something that's not actually a crime is fundamental error. And so because the state attorney invited the jury to conclude, if half of you conclude that it was to trick the Howards and the other half find that it was intended to scare Bethany, then you can still convict. I think that that was a misinstruction on the law and led to a distinct possibility of a non-unanimous verdict, along with the jury instructions that had in the alternative DJ Howard Jr., DJ Howard Sr., the clerk of courts. I think this case would be in a very different posture if the fraudulent document had been filed. If that were the case, then we would not have the venue question, we would not have the harm question, we would not have the non-unanimous verdict problem. But this was a document that was printed, presumably in Charlotte County, but we don't know. We don't know where it was altered. We don't know who did the alterations to it, but we do know it was given to one person and one person alone, DJ Howard Jr. And the fact that that person then passed it on to other people and other people heard about it does not create criminal liability for Christopher Brady. That's a foreseeability problem that was addressed in JAW versus state as far as delivering a threat. And I think that the Alanis case, Alanis versus United States, suggests that we can't have a foreseeability question in criminal cases. We have a due process right to know what's prohibited, and other people's downstream actions never create criminal liability for an individual, even if they are foreseeable. So I think the non-unanimous verdict is the distinct problem for the state and is fundamental error. The other area that we were concerned about and raised on appeal was the limitation of the development of the defense. One of the elements of uttering a forged instrument is the intent to defraud or harm. And when Christopher Brady, acting as counsel for himself, attempted to develop the information that his brother had actually established parental rights with 3 different witnesses, which we enumerated in our brief, the trial court would not permit him to inform the jury that he did indeed have the right to see the child, that the mother of the child had listed him as the father in soliciting child support from the state. And each time that came up, it was objected to and sustained, and that went to his effort to show that it wasn't an intent to cause harm, that it was an intent to enforce rights. Now, that may not have carried the day. However, the case law suggests that when we're talking about relevance and developing reasonable doubt, that anything that has a tendency to create doubt should be admitted. And that's from Roman versus State as cited in our brief. And because Mr. Brady wasn't able to develop that defense, it left the jury with the unfortunate misperception, perhaps, that the parental rights were contested or something else. But he should have been allowed to develop his defense. In Roman versus State, it was kind of a similar situation where there was a child molestation allegation, and the accused was trying to develop an animus defense to show that the other parent of the child had coached the child for reasons that she had. If in this case, it's very similar. They were trying to demonstrate for the jury that the mother of this child had applied for support, but then unlawfully restricted the visitation access to the child, and that they weren't intending to cause harm or defraud. That is an element of the offense. The jury may or may not have believed it. Nonetheless, the case law suggests that it's reversible error.
Ms. Mogensen, not to interrupt you, you're about to get into your rebuttal time. Feel free to go forward as you see fit, okay?
I do think the issues we've covered are our most critical issues, so I would like to defer to the state.
Very good. And you have about 4 minutes left for rebuttal, okay?
Thank you.
Wonderful. All right, let me see if I could clear this. All right, and I'm going to ask you, Ms. Mogensen, to please mute your microphone. Excellent. Mr. Roscoe, whenever you're ready, the court is ready.
Good morning, Your Honors, and may it please the court. Roscoe, on behalf of the appellee state of Florida, respectfully request that this court affirm appellant's conviction and sentences as to all of the issues raised in the appeal. But
and Mr. Roscoe, can I just have you zoom in on just a couple of issues? Let's discuss the venue issue. What is the state's position with respect to the venue? I realize what the court has indicated as to the reasoning why basically the court denied the motion, but I want to hear your argument on that issue.
Well, the state's position now is that the trial court was correct in the findings that it made below. In order to prove the crime of uttering a forged document, the state was required to prove, of course, that there was a forged document. And just as the trial court found below, the only way, so the forged document in this case, of course, came from the actual service of process summons that was filed in Matthew's case in late November of 2018. So the trial court found that the document actually came from there. So the forgery actually came from there. And then when it was passed by the defendant, by the appellant in this case, it was passed with the intent to have an impact on the paternity petition and the custody dispute in Sarasota County. So that was, in that way, the state believes that there was a sufficient link to Sarasota County in order for the appellant to be prosecuted there. And as far as the case of Berry versus State and using the two-way communication device to facilitate fraud, in that case, there was no indication in the opinion of this court that the state ever argued section 910.05 or that the state proved anything about venue at all where the action occurred. I mean, they had apparently no idea where he actually made the phone call from. So that case is not, it doesn't really compare to this case. Here, the case started.
If I could follow up with that, Mr. Roscoe. So what you're arguing is the fact that the actual instrument that was ultimately forged was either downloaded, there was testimony whether it was downloaded, whether it was by email or something, using some computer to download an official document from Sarasota County and then to alter that document. And so by virtue of that downloading and taking it from Sarasota County, that's what established that venue would be appropriate, and realizing that it was the effectuation and the actual uttering of the forged instrument was accomplished in another county, that basically your positions, it could have been, or at least that was the judge's and the state's position, could be done in either one.
Correct, Judge, that's correct. And that is the state's position, that he could have been prosecuted in either, because that's where the actual document came from. It's not like the state was arguing below that he just created a document out of nothing. He actually used the document from a case based in the Circuit Court of Sarasota County. So, and that's why the state believes that Sarasota was proper venue in this case.
And that kind of ties in then with the one of the last issues that Ms. Mogensen raised in terms of who the ultimate, if you look at the instruction of the jury, that whether or not Christopher Beatty intended to issue and or defraud, and there was a lot of and or of several folks. Address that for me, please.
Well, Your Honor, first of all, nothing about what the state argued below and nothing about what we're arguing here suggests that the appellant was being punished by being convicted for the downstream harm. In fact, harm is not even an element of the offense. It's the only element is whether or not he had the intent to defraud. So in this case, all the state was required to show was that Christopher Brady passed the document as true, knowing it to be false, intending to injure or defraud any person. If the jury, and just as even as the prosecutor argued below, if the jury believed that he intended to injure or defraud DJ Howard when he handed them the document, or if he intended to injure or defraud Bethany by giving them the document, because I know in the, I'm not sure that was mentioned today, but at least in the briefs, it was suggested that the only reason that the document was passed was to learn about the whereabouts of the child. And that's certainly an argument that could be made. But the actual language of the forged order says that the respondent shall return the child to the petitioner until further order by the court. So the jury was certainly free to believe that based on the information contained in the forged document that when the appellant passed the document, he was actually trying to use this, the authority of a Sarasota judge, to gain possession of the child. And whether or not, and as far as the intent to injure or defraud DJ Howard, of course, that was established whenever he passed the document to DJ Howard. And because the testimony from Matthew was that they believed that Bethany was actually at the property in Charlotte County whenever, DJ Howard's property, whenever he passed the document. So it's clear that he did intend to injure or defraud. Now, all the state was required to show was that he intended to injure or defraud any person. So just as the prosecutor argued, if he intended to gain possession of the child by defrauding Mr. Howard, or if he intended to defraud Ms. Stryker whenever he passed off the document, even if the jury disagreed about who he intended to defraud, they unanimously agreed that he intended to defraud any person. So this is not a case like Miller versus State, where the state charged the defendant with an alternate theory, whether or not he used a deadly weapon or whether or not he caused great bodily harm. That those different theories would require that the jury make a separate factual finding. He either used in one theory, he either used a deadly weapon, or in one he caused great bodily harm. Here, the state was only required to prove that at the time that he passed the document, he had the intent to injure or defraud any person. And it's very clear based on the facts of this case that he had the intent to injure or defraud at least the individuals that were listed in the information and the jury instructions. And so for that reason, it was not error, and certainly not fundamental error, justifying reversal. And as for the issue number 2, the judgment of acquittal based on actual knowledge, a review of the events that occurred in the case of leading up to the time that the defendant passed the document would probably, it's all circumstantial evidence, of course, but Matthew testified that he filed the petition for paternity in late November, and that the summons served was filed on December 11th, and that in his words, he originally intended that the case be kept, quote, low key, or in other words, just a smooth process between Bethany and himself. That is, until she waited until the last day and hired Mr. Santee to file a notice of appearance and a motion to dismiss on December 26th. After that, that's when he went to his brother, and that's the whole reason that appellant got involved in the case was because Mr. Santee became involved in the case. So then whenever appellant filed a notice of appearance the very next day, and the forged order is dated December 29th, he passed it on December 30th. And actually the language of the order, the beginning of it says that this action coming before the court on petitioner's motion for entry of a default and emergency motion to return child. Well, between Attorney Santee and Matthew Brady, they had testified about what had occurred before Mr. Santee filed his between the filing of the petition for paternity and Mr. Santee filing a notice of appearance in the case. And that was not it. Appellant knew that whenever he went and passed this document, he knew it to be a forged document. That was certainly enough circumstantial evidence from which the jury could infer guilt in this case. And as for the final issue, I believe that those are issues raised across 3 and 4 as far as how they were briefed. And I do want to point out very quickly that although I did not mention this in the state's answer brief, none of these arguments were made to the trial court below. Whenever appellant tried to ask a question, for almost all of the questions, appellant would ask the question, the state would object, the judge would abstain, and he would move on. So these legal theories raised on appeal now were not argued to the trial court below. Arguably, and the only issues argued here are whether or not paternity, or appellant should have been able to establish paternity, or that Matthew established paternity through the Department of Revenue. Well, whether Matthew was the father of the child, I still am unclear about how that was relevant to whether or not on December 30th, appellant was the individual that passed the forged document. So it's irrelevant as far as I can tell. And also because nobody disputed the fact that Matthew was the father of the child, at least not at the time of trial. Ms. Stryker's answer to her 5th question on direct was that Matthew was the father of the child. So it did not matter that that information wasn't relevant. The trial court properly excluded that information. So if there are no other questions from the panel, then the state would rely on the brief for the remainder of the arguments and request that this court affirm.
Very good. Very good. Thank you, Mr. Roscoe. I'm going to trouble you to please mute your microphone. And then Ms. Morganson, you do have your 4 minutes for rebuttal, ma'am.
Thank you. I think the source document is a distraction. If you look at the plain language of Florida Statute 910.03 individuals are to be tried where the offense is committed. There's no nexus element. There's no where the document came from element. You're to be tried where the offense was committed. To say that because the document that was altered came from Sarasota County and affected a Sarasota County case is the same as saying, if I altered my birth certificate from the state of Wisconsin and passed it in Sarasota County, Florida, that the proper venue would be Wisconsin because that's where I was born and that's where the document came from. It leads to an absurd result, and it's contrary to the plain language of the statute. Here, as compared to the DeSoto County case with venue, Berry versus State, in Berry versus State, there was no evidence of where the venue was. And I think the fact that a communications device was used is a distinction without a difference. The offense was committed using a communications device, but if it had been in person, a fraudulent statement, the result would be the same. It would be where the statement was made, and the state was not able to prove that. Here, it's not a circumstance where the state couldn't prove venue. The state proved venue was in Charlotte County, Florida. The evidence came in that the document was passed and uttered in Charlotte County, Florida. And so in that regard, the Berry case more strongly suggests that this conviction needs to be vacated because it was proven where the venue is and where the defendant was tried in the incorrect venue. With regard to the any person argument, with regard to intent to harm any person, the language any person invites the precise error complained of. It invites the non-unanimous verdict, which is in violation of our constitutional principles. People are entitled to a verdict that is unanimous in the state of Florida. And to say any person, I mean, that's the most egregious error in the jury instructions of them all. And I do think that we need to look back at Bush, that there has to be competent, substantial, meaning non-speculative evidence of each element of the offense. And the knowing the harm, the intended harm, has to be proven that the defendant, the accused, intended the harm. And it cannot be said that the defendant intended to harm anyone that the defendant could not anticipate would be given the document. If you think about this as a practical matter, the document was produced to get an answer right now, today at the door. It would be absurd to think that either Matthew or Christopher Brady intended this document to be given by the Howards to anyone else, because of course it would get them in trouble. Their objective was to find out where the child was, and obviously they gave that document to the people that they thought had the child to get an answer. To speculate that somehow they thought that this was going to get into the case and shift that it was going to be believed that the court granted some type of rights that weren't granted is an absurdity, and frankly, they're facts, not in evidence. We did not spend much time talking about the prosecutor's argument regarding facts not in evidence, and I did not want to leave that unaddressed. I think that I would ask the court to address the state prosecutor is telling the jury that he had 400 police officers' names in his phones, and if he asked them to do something, they would, and the other enumerated arguments that crossed the line of an independent forum, a non-partial forum, arguing facts not in evidence, speculating that the Brady brothers went to a residence and forged the document themselves when there was no factual foundation for those arguments, is quite egregious. And I would ask the court to address those in the ruling, because it is something that I think it was a closer case than maybe the state thinks, and that it definitely is something that likely tipped the scales in favor of the state, and should be addressed by this court.
Very good, Ms. Mogensen. You actually managed to get all that in your rebuttal time. So this is great. So thank you both very much. I'm going to ask you at this time to please